have to be very now cautious, but at the same time decisive in what happens. Just Sanjay Sahay joining us to have a conversation on what is a difficult time. Let's not also underplay it. This is complex. It's to my knowledge unprecedented. Nothing like this has ever come out. It is serious enough for an inquiry to have been ordered. It's serious enough for the registrar of the Chief Justice of the Delhi High Court to visit the residence and conduct an inquiry. It's serious enough for the Delhi Commissioner of Police to have gotten involved. It's serious enough for the Chief Justice of India to have gotten involved, and they have made the right call, which was to publish the information pretty much in toto. Other than names and phone numbers, nothing has been redacted. That, as a person who has to face the other tedium of trying to figure out how not to speculate while at the same time not to presume that nothing has happened, that serves the purpose of fighting disinformation or misinformation with what is information. So every single photograph that you now see on your screens, every single point of information that you see on your screens, the source is now the release from the Supreme Court last evening. We are not putting it out from anywhere else for that particular reason. Now, it is interpretive, as Justice Kaul has just mentioned, on what can be seen. What is the quantities of what can be seen? How do you forensically examine what the destroyed articles or the charred articles were indeed? Were the majority of them banknotes, or were there few of them banknotes? If the majority of them were indeed banknotes, what would be the forensic evidence left behind? It is clear in the imagery that at least some part of the detritus that has been recovered or photographed constitute banknotes. Does that necessarily mean that it was a room full of banknotes which would tantamount to X number of crores of rupees? Were it indicative of pre facto that they existed or were placed or were incidentals? We have a lot to figure out, and of course the nodal agency investigating this, to the best of our knowledge, as released by the Supreme Court, is the Delhi Police. The Delhi Police Commissioner is the one who's been requested to do this. I'll thank Justice Kaul. Justice Kaul, thank you for joining us. Let's open up this conversation. Let me get our reporters into this conversation as well and pick up this thought, which is a complicated thought. Vikas Gupta is with us, Sanjay Sahay is with us, Joyita Basu is with us. Sanjay Sahay, let me come to you, Mr. Sahay. Now, we know that the Commissioner of Police has been asked by the Chief Justice of the Delhi High Court under a mandate from the Chief Justice of India to look into the matter. Now, I've raised the points. We have understood that they're making a list of all the people who had access to this outhouse. They're making a list of all the people who were present during the time of fire. They're making a list of the phone records of the said judge. They're making a list of what articles were indeed found. Now, what kind of forensic examination can actually be done, to your best knowledge, Mr. Sahay, that would help us establish what percentage of the detritus or the burnt remains were actually banknotes versus sundry materials?
See, we will get into the forensic part of it in just a while. Suffice to say that whether it was 50 lakhs or 50 crores is not going to make any difference, and the culpability of the crime remains exactly the same. If people are trying to disorient the whole argument that the total quantum of money which has been found there, that is of any consequential value, so that is primarily for laymen and primarily for social media and things of that nature. As far as the crime as such it is concerned, it is 50 lakhs, 1 crore, 2 crores, whatever the case may be. There was money there, money has been found, fire force people were there, police were there, the whole thing has been done. Now, this is not a criminal investigation. Let's be very clear about it. So, lots of things have not been done as it can be done, or it should be done as per the processes of criminal investigation. And our honorable judges, they know it the best as to what is not properly done by the police and what are the lacunae thereof. Now, what has been asked, if I go by whatever description you have been giving, whatever has been asked about from the Delhi Police Commissioner or Delhi Police, now they will stick on only to whatever has been asked. The actual investigating agency, instead of a police or any investigating agency, is the inquiry committee appointed by the Supreme Court of India. Now that becomes the principal criminal investigation agency. To best of my understanding and knowledge, the investigation capabilities finally, or it is mandated, legally mandated to rely on the investigative agencies. So if there is a criminal case which is being made out based on the inquiry conducted by High Court, Delhi High Court Chief Justice, then the only way is to get into the criminal investigation process of this country. If we believe that for some people, whatever might be the case, the criminal investigation process can be done in-house, then that is an open question. I'm leaving it to you. And this whole process of conduct and all those things and impeachment is for different reasons. When it is a pure criminal case, it has to go to the criminal way. Now coming to the forensic part of it, there is enough and sufficient methods to forensically examine even that video footage and that particular couple of those images to come to some conclusion regarding the quantum. Not that it is of any consequence, because the judge has straight away denied that I have nothing to do with this, and it is all a planted story. Now the other part is, at what last point, we talk about in the missing case, we say, which is the last point when the person was seen, who has gone to this particular room and can confidently say that these were the things which was there in that room, which means from that particular date and time till the time this video footage has come out, it has been planted at that particular point in time. If there are people who are able to tell us, because the Honorable Judge would like us to believe that it was an open sort of a room where anybody could come and everybody could come, and there is a security guard or a security platoon which is just outside, and still that ingress and egress is provided. There is also the finding of the Delhi High Court Chief Justice, which says that the room was guarded or that anybody and everybody could not go. So first forensic evidence will be related to whatever is found there. Now whether this has been taken up in a Panchnama and all that, I think all those procedures would certainly have followed, and this would be somewhere in the Malkhana.
Mr. Sahay, now of course there are certain things we don't know, but prima facie what was put in public a few days ago was a statement which is published on the website of the Delhi Fire Service. The Delhi Fire Service did not mention any bank notes in its report, although it is clearly visible that there are fire officers in the place where the fire took place, where we can see the bank notes, and that has been videographed. So the fire officers were there, the bank notes are visible, but the fire chief came and said that we have not recovered any bank notes. Now technically you can say recovered means to removed from the premises any items.
See, whether what Delhi Fire Chief had in mind when he made this statement, I am not aware of. The call went to 112 or 100 or whatever you call it in Delhi, and then the call was transferred to the fire force, and I think there's a police complement also which would have gone there, which is recorded by these people there. Now one thing is very well established, and if we intend to believe the report which we are talking about and which is the primary piece of discussion today, is that the Delhi High Court Chief Justice has already established that there has been a stockpile. Whatever has been the stockpile is a different thing, and it is precisely for that reason that video has been put in the public domain.
Okay, I just want you to hold your thought because I want to read from the registrar's report. This is the in fact the report that has been submitted to the registrar to the Chief Justice of the Delhi High Court, and at the end of it the Chief Justice writes, the inquiry conducted by me prima facie does not reveal possibility of entry or access to the room by any other person than those residing in the bungalow, servants, gardeners and CPWD personnel, if any. Accordingly, I am of the prima facie opinion that the entire matter warrants a deeper probe. So, Mr. Sahay, in the assessment or the preliminary prima facie assessment of the Chief Justice of the Delhi High Court, he says that it is very unlikely that there is a third party who has jumped over the wall and gained access to this storage room. So somebody had to have access from within the house. Now that could be CPWD, that could be gardeners, that could be staff members, or indeed others. So does that preclude something for us?
Yes, in the simplest of cases and most difficult of cases also. It is how somebody can gain access or cannot gain access. So in the last 6 months, whosoever has gained access there, that is very neatly documented. You might not have the name. If you get into the duty timings or the duty roster of the CRPF person or CPW person, I think literally everything can be tracked in possibly no time. So from there you can start, and you can certainly preclude as to who could have been there and people who could have been there. I think the investigative agency knows how to proceed with it. Whether the in-house inquiry committee will go into those investigative processes or
Okay.
not, I'm not sure of.
Okay, one more point,
But
sir.
there'll be enough and sufficient evidence which will see, we are making a huge complex case out of it. Leave aside the person who is involved. Leave aside the way the smoke screen has been created because of legal immunity or otherwise, and the delay and all that. Otherwise, it is not a complicated investigative exercise. Let me tell you very
Okay,
clearly.
okay. I just have one more point, sir. The Chief Justice of the Delhi High Court also says in his report, on examining the incident reported, the material available and the response of Justice Yashwant Verma, what I find is that the Commissioner of Police in his report dated 16th March 2025 has reported that as per the guard posted at the residence of Justice Verma, the debris and other partially burnt articles were removed from the room where the fire had broken out in the morning of 15/3/2025. Now, Mr. Sahay, if the room of course is not sealed, can we now, how do we assess what was actually in there if we are being told that certain debris were actually removed?
From the second Delhi police has arrived onto the scene, or fire force has arrived onto the scene, more so when Delhi police arrived onto the scene, till the time this debris is taken out, it is the responsibility of Commissioner of Police Delhi to give you a sequence of events and what are the legal processes followed, under what section, what was seized, taken where it is. We cannot be in doldrum saying that somebody has carried on the 15th morning. When he is giving all those pictures and he has communicated to the Delhi High Court Chief Justice, and then it was communicated to the CJI of India. So it is his prime responsibility, and to best of my understanding and knowledge and expertise which I carry, certainly these things would be documented and should be satisfactorily proved to the inquiry committee. My challenge is somewhere else. Now these lacunae have taken place because there is no investigation. And now again the inquiry committee is there, which does not have the specific expertise in investigating such cases. Now, while this inquiry committee goes on, there will be other lacunae and other things which will turn out to be a smoke screen. Or tomorrow in the judicial trial, if a PCR case, if a prevention of PCR case has to be taken, then these lacunae might stand against the prosecuting agencies. We don't know.
Okay, so for people, finish your thought.
And there are enough, I'll just take one line. The technical evidence which is available in this case, by way of CCTV, by way of call data records, by way of other variety of other things which are there, their servers, their communication, email, Delhi police logs, fire force log. You remember of the Narasimha Rao case? Then they said 1 crore was paid to him. And there were 25 logs which happened on a normal basis. See, what evidence is critical to us, which is generated in a normal process. It is not a specific thing which is brought to you. So there are lots and lots of logs, information, data, which comes in the normal process. If that is collated and that there is a pattern put to it, which will not be very difficult because all the personas which are involved in this are limited in number.
Mr. Sahay, what we do not have access to is the confidential report which has been made by the Police Commissioner of Delhi to the Chief Justice of the Delhi High Court. We have the summary of the Delhi High Court Chief Justice which has been put in public record. Now, I don't know, and I'm sure, of course, you also do not know, but if the police officers had happened upon, they were not expecting a crime, they were expecting a fire, but they happened upon such articles, obviously they were alert enough or had proper procedure that they were anyway videographing and photographing the sign of the crime, which is why we have the prima facie, what we have to call now evidence. But at the same time, would they be treating this like an investigation, or would they simply be videographing it and informing their superiors? Or would they be writing a panchnama? Would they be sealing the room? What would they be doing?
No, if it is lied unclaimed and there is a likelihood that this is proceeds of a crime or it is related to a crime, they would have followed the processes, though FIR is not there. But processes of those processes would certainly have been followed. Because even if there is inquiry to happen, something would happen. Some legal process will take place that Delhi police was aware of, and that is where the whole process has actually started. They would be convinced of the fact. Any police officer would know what it would transpire. He might not exactly be able to visualize the nature of things which has transpired, but he will know what he is supposed to do. And if he has not done that, then that is a huge discrepancy, irregularity. But I'm sure. And see, what has been provided by the Delhi Police Commissioner is factored in the report which has been given by CJI of Delhi, of the Chief Justice of Delhi High Court. We are not privy to that, but he has gone through the whole thing. And if he found something amiss, that would have factored in here also. So I presume till this time, from a judicial scrutiny point of view, because the main person who was actually inquiring in this is himself a Chief Justice of a High Court of this country. I think this back-end processes, legal processes, police is supposed to take, in case there is a suspicion of a crime, would have been done. If it has not been done, we will see how it opens up.
Okay, so now let me. I'm sorry, I'm still troubling you, Mr. Sahay, with question after question. But for people watching the broadcast, had this been an ordinary citizen, and there was a case of fire, and upon arrival at a residence or at a storeroom, large wads of cash were found, what would be the process for an ordinary citizen? Let's put aside, like you said, who the individual currently is. What would happen? What would transpire?
Straight and simple. The fire force would have informed the police if they did not come together. But because it was a High Court thing, so High Court judges also. So FIR will get registered. After the FIR is registered, all the other processes of seizure, Panchnama, Panchas, everything will be followed.
So for any other person, the FIR would have been registered almost immediately, and this police could register an FIR.
Instantaneously. Otherwise, leave aside the SHO, the commissioner is at risk. And the same judges will find gaping loopholes in that. Correct. So we cannot take that risk. As an ex-police officer, I'm saying we don't take that risk. Case is there, register an FIR. Where is the question of this amount of money, that amount of money? Where is the question whether the propriety and morality of the society has gone down? Where is the question of conspiracy and planting? None of this.
Okay, so does there exist a different procedure when it comes to judges who, of course, have constitutional protections? Is there a different procedure? Because what we now assume here is that the videography was first shared. Does there exist a different procedure for judges, sir?
No, it is a different procedure. No, everything till now, everything has been in-house. But a report which has been given by Commissioner of Police Delhi to High Court Chief Justice, Delhi High Court Chief Justice. It is not a normal procedure. It is something, and that exception has been provided. That exception has been provided, that legal and constitutional immunity, because it is told that the nature of job they do will attract this sort of behavior by people who will insinuate and variety of other things. But the point is, when there is a criminal activity which is there, now whether that criminal activity and presumed or whatever you call it or alleged, if there is a criminal activity and if there is a suspect thereof, will this legal and constitutional immunity is in tune? Okay. That is what I want to ask.
Okay, Mr. Sahay, is it possible for an investigation to proceed without an FIR, or do we at some stage require this committee to ask the police to indeed actually file an FIR?
The committee will have to, the collegium will have to instruct the police to file the FIR. So primarily it means the FIR will be effected only when the Chief Justice of India gives those instructions. And this is the case with a couple of other exceptions also. But it has to be directed by the collegium after this inquiry is over. They might also decide that there is no need of a criminal case. See, the options, I'm talking of the options, what they decide, I don't know. Or what the final report will come, nobody is aware of. But the point is, so going for a criminal investigation is not a necessity in the given scheme of things. But if you take a common understanding and the way the whole thing has happened and transpired, and the knowledge of the criminal justice ecosystem and the processes, in today's day and time, it is next to impossible to digest that criminal activity of this nature, prima facie, as per the whatever has been reported upon, can be handled only through legal and constitutional immunity and through in-house processes.
Okay.
That is. See, the world has changed. Why was the Supreme Court of India? We compliment Supreme Court of India and the Chief Justice of India for having put everything in the public domain. But why did they do? They have never done it. First time. Perfectly fine. Why did they do? Because of this intense pressure and the nature of suspicion which was created. From my point of view, they are forced to do. It is not a smoke screen which we created.
Okay.
It is a smoke screen which they created.
Mr. Sahay, just stay with me. Let me just read out now what the judge in question here, Justice Verma, has in a 6-page letter dated the 22nd of March, which has been released by the courts last night. Now, what he says.